Dear colleagues, dear candidate and the public, today on January 19th of 2025, the advisory group of experts has gathered in full composition to conduct interview with a candidate for the position of a judge of the Constitutional Court of Ukraine, Konstantyi Oleksandr Volodymyrovich. During the interview, members of the AGE are present. Secretary of the AGE, Madam Maureen O'Connor, member of the AGE, Madam Hanna Sukhotska, members of the AGE, Mr. Yaroslav Romanyuk, Mr. Aleš Zalar, Mr. Vasyl Shakun, as well as I, Chair of the AGE, Oksana Vasilchenko. During the interview, we also have deputy members of the AGE present, Mr. Vitaly Makhinchuk, Mr. Richard Barrett, Mr. Marek Zubik, Mr. Volodymyr Kuzmenko. I would like to point out that we are working in a shelter, so in case of an air raid alarm, the interview will continue without interruption. I would also like to remind you that the interview is being recorded and broadcast live at resources of the AGE and at the website of the Constitutional Court of Ukraine. I would like to draw attention of the AGE members and of the candidate regarding restriction of the use of sensitive data and restricted information during the live broadcast. If it is necessary to discuss such issues, the AGE will suspend the broadcast. We are ready to start. So I would like to pass the floor to Madame Maureen O'Connor, Secretary of the AGE, for a brief introduction of the candidate and reminder of the interview rules of procedure. Maureen, please, the floor is yours.
Thank you, Madam Chair. Welcome. Good morning to my colleagues and to those who are watching us today and to the candidate. As the Chair has already said, the advisory group of experts will now interview the candidate Oleksandr Konstantyi. Let me remind you that an interview is a mandatory stage. In other words, the opportunity to interview is mandatory. And the stage for the assessment of candidates is part of the evaluation of their compliance with the criterion of high moral quality. The time limit for the interview is no more than 1 hour, and the time limit for answering each question is no more than 3 minutes. Traditionally, we would ask that all candidates be concise and to answer clearly and to the point of the question that has been asked. At the end of the interview, the candidate may make a short closing statement of no more than 5 minutes. I would also note that while processing the materials on candidate Konstantyi, the advisory group of experts sent him questions for written explanations, so the candidate had the opportunity to prepare and to provide answers for this interview. So now we have with us a candidate for the position of judge of the Constitutional Court of Ukraine, Oleksandr Konstantyi, who was admitted to the selection process by the selection commission affiliated with the President of Ukraine. He is currently an advisor to the chair of the Central Election Commission and a professor at the Department of Constitutional and Administrative Law at the National Transport University. He has extensive experience in legal work in the Secretariat of the Verkhovna Rada of Ukraine, the Supreme Court of Ukraine, and the Constitutional Court of Ukraine. He holds the academic title of Associate Professor of the Department of Justice, as well as the degrees of a PhD and Doctor of Law, having defended his dissertations on the sources of administrative law in Ukraine in 2000 and protection of rights of individuals and legal entities in administrative proceeding, problems of theory and practice in 2016. He is the author of 160 scientific papers and honored lawyer of Ukraine. Mr. Konstantyi, if you would like to add anything to the information that I have just shared, you may do so now with a time of up to 3 minutes.
Дякую.
Thank you, Madam Maureen O'Connor, for the introduction of me as a candidate. I would like to add that while working in the apparatus of the parliament, my work was directly related to the preparation of the position of the parliament as one of the parties involved into constitutional proceedings at the CCU, because this is the body that adopts provisions of the law. So basically, for about 5 years, I dealt with preparation of positions of the parliament, with interpretation of provisions of the constitution, provisions of laws, different means and ways for justification of constitutionality, unconstitutionality of laws. Similarly, while working in the Supreme Court, I also, first of all, I represented the Supreme Court of Ukraine in 2010. And in cases of constitutional jurisdiction at the CCU. Besides, I dealt with preparation of constitutional submissions, because judges of local courts address the Supreme Court of Ukraine, which is now called the Supreme Court, so that the Supreme Court would submit this constitutional submission to the CCU. Besides, after competition to the Supreme Court, since the new law of the CCU was adopted on July 13 of 2017, since I did not pass the competition and I was not offered to work in the new court, I moved to the patronage service as an academic consultant for Judge Melnik, and once he retired, I worked in the support service as a consultant for the Judge Koliznik at the CCU. During this work, I directly work with preparation of draft documents and acts of the CCU, including rulings on opening of the proceeding, on refusal to open proceedings. I know the methodology of interpretation of provisions of law in constitutional proceedings. I understand which approaches should be applied during drafting of decisions. I know which procedures take place in the Constitutional Court with respect to consideration of constitutional submissions, their movement. So a large part of my life has been connected with not only administrative law, since I have not taught administrative law since 2002, but my life has been mostly related with constitutional proceedings. Thank you.
Thank you.
Dear colleagues, let's move on to questions to the candidate.
Start, if I may. Good morning, Mr. Konstantyi. My name is Oleksandr. I'm a member of the AGE, and I have several questions which are aimed to clarify certain issues related to your property and sources of funds based on which this property was obtained. I will start with the question about your apartment, which was purchased back in the year 2009 in your name in Kiev, in a total area of almost 71 square meters. As the advisory group has found out, you and your wife has been living in this apartment since 2009, and the purchase price of the apartment was 731,000 Ukrainian hryvnias, which is equivalent to 95,000 US dollars at the exchange rate of the National Bank of Ukraine. Could you explain the sources of funds for the purchase of this apartment, if possible?
Thank you, Mr. Oleksandr, for your question. Because a requirement to candidates, of course, is to check their financial and property situations, because judges of the CCU are potentially public persons with respect to whom monitoring is conducted. With respect to this apartment, these events took place 16 years ago. Everything happened in line with the current legislation. In particular, on September 1st of 2013, only 4 years later, the resolution of the NBU was adopted with respect to restriction of cash operations, which set out that 150,000 hryvnias, if the object is more expensive than that, then the transaction should be cashless. The apartment, the source of origin of funds for the apartment was my salary. Since 1999, I've provided such information about my official income. Besides, this was also salary in the apparatus of the parliament. It was salary in the Supreme Court later on. Also, I engaged in teaching in 2-3 universities all the time. In one of the universities, I was teaching in the afternoon after work, since it was the afternoon studies, so I could teach after 6 p.m. Besides, when I came to the Supreme Court, I taught in the National Academy of Judges of Ukraine. There, I also had either 0.25 or half the law on the civil service allowed me to teach. Besides, the source of origin of funds included, first of all, I would like to mention that this apartment is not in a prestigious neighborhood of Kiev. This is on the left bank of Kiev. It's not an expensive apartment from the perspective of understanding of having sufficient income for that. On that day, we sold one-room apartment, which we owned since 2004. We added funds and we bought this apartment. During that period of time, the legislation did not envision that that had to be a cashless transaction, because back then the global financial crisis was ongoing, and 1/3 of the banking system was insolvent back then. So accordingly, on the day of the transaction, we were selling this one-room apartment and we were buying this apartment at the same notary's office. On the date of the sale and purchase, it took place in the Kiev center. We went down to the bank. We exchanged foreign currency, which we were saving because we did not repair the one-room apartment, because we were hoping to expand the area of our residence, because back then my daughter had a bath in kitchen and I did not have an office for my academic activities, so we had very minimum furnishing in that apartment, and we counted that we would have the opportunity to buy a bigger apartment. Once I worked in the apparatus of the parliament, and when I worked in the Supreme Court, I tried to exercise my rights to get 0% mortgage maybe, or maybe to participate in some youth housing program. Back then it was the time, and I did not have any opportunity. I did not take part in privatization, and the funds that had been earned were stored, taking into account tendencies that were happening back then. So we accumulated savings in foreign currency. On the eve of 2009 in Ukraine, for some reason, the currency exchange rate was lowered. It was below 5 hryvnias per $1. Back then, we were exchanging our free funds into foreign currency. So, on the date of the transaction, we exchanged in the bank's cash desk this amount of funds. By the way, it was not $95,000. It was the connection to the foreign currency, so that the seller could not review this transaction. The real currency exchange rate was different. It was 7.7, that is the NBU's currency exchange rate on that date. We exchanged these funds in the bank. We gave them. We also added funds from the sale of our apartment. So we paid this payment and we also paid payments to the notary. We had to submit these documents to the notary as well, and we concluded this transaction. So everything happened in line with then current legislation. Thank you.
Thank you for this extensive answer. If my understanding is correct, so this was the money which was paid in cash, and at that time, as you said, this was according to the law. But I have another question. You informed the advisory group in your written explanation that apartment was purchased in a no repair condition. Please explain the periods of repair and the approximate amount of money you spent on this repair, as well as the source of respective funds.
Thank you, Mr. Alish, for this question. Given that the apartment was without repairs, it was a newly constructed building that was just commissioned, and we were executing this transaction when it was possible to move into this building. The previous buyer of the apartment, of this one-room apartment, established a harsh deadline so that we vacate that apartment because they needed it back then to move into that one-room apartment. So we gathered all of our stuff and we moved into this apartment where we had only the concrete floor. We made some temporary place for rest in one room, and gradually we installed temporary strategic equipment, and for about 2 years we were conducting some works, having some experience back from Kharkiv because we had an apartment there as well, and we were repairing on our own. We were plastering the ceiling and putting the wallpapers. So we performed some works on our own. For some works we invited people like to lay the tiles because I don't know how to do that, of course. For about 2 years we were doing that. We were furnishing.
How much money did you spend for this repair?
Up to $10,000, because we were working together with my wife. Back then our salary was official, and every month we received funds. And by the way, back then in the Supreme Court I received the salary in cash as well, because bank accounts did not exist in the current understanding. So we received funds in cash, and we used these funds to pay for these repair works gradually. Our daughter did not live with us. In summer she was with her grandmother, and we at least made one room where it was possible to live, and gradually we were doing that.
There was no other way to do it.
Let's move to the next question. You explained that one of the sources of funds for the purchase of a two-room apartment in 2009 was the proceeds from the sale of your one-room apartment with a total area of 39 square meters. You explained in writing that you purchased this one-room apartment in 2004 for 150,000 Ukrainian hryvnias. What was the condition of this apartment when you sold it in the year 2009?
Thank you for your question. I already said that this was a one-bedroom apartment, and the previous owners, they also got it on youth program in Kiev, and there was also linoleum of the Ukrainian producer. So I provided you the photo of that apartment of my wife. That was the condition of it. The Arcada Bank gave it in that condition. We also had to do the wallpapers, and there was no expensive repairs there because we were counting on that we would extend it or enlarge it. This was a temporary accommodation where we have resided for 5 years, and we're collecting funds to extend it.
Did you make payments for this 2009 sale of this apartment?
As I already said, the resolution of the National Bank of Ukraine, only as of September the 1st, 2013, it was established that all calculations that subject to notary certification and exceed 150,000 hryvnias, they're subject to banking. And back then, the banking system was it collapsed, and many people lost their savings in banks because the settlement was frozen. We had savings in the USD currency. We exchanged in the cashier bank next to the notary office these funds. This was amount not $95,000 but $91,000 in accordance with the exchange rate at that time. And then the seller, they did the reverse transaction, and they purchased these funds with the exchange rate that was the one on the sale. Then, so the settlement, in hryvnia.
Since you mentioned the exchange rate, this apartment was sold for 100,000 Ukrainian hryvnias. This is equivalent to 13,000 US dollars at the official exchange rate of the National Bank of Ukraine as of the date of sale, which was 30th of April 2009. Accordingly, in US dollar equivalent, the value of 1 square meter of this apartment was approximately 332 US dollars. At the same time, according to publicly available information from real estate agencies, the average price per 1 square meter of apartments on the resale market, this district, Darmitsky district of Kiev, where the apartment you sold was located, as of April 2009, was much higher. It was 1,242 US dollars. So how can you explain the sale price of this apartment, which was significantly lower than the average in Kiev at that time?
Thank you for your question. And as I have added to my explanation, this apartment was in the unattractive, unfavorable region. Back then, the mayor who was participating in the elections promised to improve the environmental condition in this region. But when we were selling, we were money to extend our conditions, to enlarge our conditions, and we were forced to sell, to do the urgent sale. And many sellers did not agree because back then since it was already warm, there was smoke in the air all the time, and many people refused, given that environmental situation, to buy. Therefore, this was the urgent sale. Apart from that, according to the data of evaluation of this property, which was not done by the expert, but the specialists of the Bureau of the Technical Inventorization of the city of Kyiv. And this apartment, according to the evaluation data of this Bureau for Technical Inventory, was 41,000 hryvnias. Since it was the urgent need, we agreed to these conditions.
Of course, you didn't pay income tax with respect to this sale, right?
Well, first of all, this apartment was in my ownership for 5 years, and the tax authority that was valid back then, I was not supposed to pay the income tax, personal income tax from this apartment. Apart from that, I also would like to mention one more thing. The circumstances that I was describing of the purchase of this apartment, they were checked and verified in 2015 and 2016, because in 2014 in October the law was made on so to say, the purification of the powers, and they were checking the property of all civil servants. By the way, this law lost its validity in October 2024, but that law envisaged that the property status of all civil servants will be inspected. And so this was checked also by the tax authority. I mean, the agreement was checked by the tax authority in Darnitsky region, and during the inspection, and the tax authority did not express any questions. And this certificate has been provided to the advisory group of experts together with my materials and application. Apart from that, I participated in the competition to the Supreme Court, Cassation Court in 2016. In accordance with the competition, these circumstances were inspected by the High Qualification Commission of Judges of Ukraine, the Public Integrity Council, and no issues in that situation occurred. So I'm just trying to say that the inspection took place twice of the circumstances, which took place 16 years ago. Everything was in line with the current to that time legislation. Thank you.
Thank you for this explanation. I have a next question. Your wife owns an apartment with a total area of 43 square meters in Kiev. As the documents you provided show that during 2014, altogether 476,000 Ukrainian hryvnias was paid to the developer as the cost of this apartment. Could you explain what sources of funds were used to purchase this apartment?
Thank you, Mr. Alash. I have provided the AGE the receipts on the transfer of funds, and they partially were given to the cashier to the Arkada Bank, and I provided you the receipts that I stored, that I got. At that period of time, we had the remains of money on the bank account that could completely cover the cost of this apartment. Apart from that, I will explain why we decided to purchase this apartment, because we had money, so partially in dollars. They were frozen in the commercial bank. They were deposited on the exchange rate 8 hryvnias, but then we were paid for the apartment, the exchange rate was 25 hryvnias. So given that this was an opportunity to preserve the savings to a certain extent, we paid money from the remains of the funds that we had in the previous years, and we worked and received salaries, and as I provided the receipts, the amounts, they did not exceed our income and our capability. So everything is confirmed with all documents, and these were legal sources of income.
Declare to the tax authorities the income received from renting this apartment, because obviously you are renting this apartment. So did your wife declare to the tax authority the income?
Так, дякую за запитання.
Thank you for your question. I did provide this information, the copies of the receipts about the taxes paid, and all taxes were paid. We purchased because, first of all, we tried to preserve the funds that were devalued because of the Crimea annexation and very rapid devaluation, and also our daughter was growing up, and we also had two grandmothers, the elderly, and we thought it was a good idea because it was next to our residential building, and for that time there was no urgent need, and the way that we rented it was actually refurbished, and we paid all taxes. We provided information declarations. We paid 18% on the income tax and 1.5% of the military fee every year.
I will now ask you something which relates to the electronic declaration. Your electronic declaration for 2021, you declared an asset under construction, an apartment in Kiev with a total area of 43.46 square meters. The date of acquisition of the right was 27th April 2021. As you stated in your written explanations, this is an apartment invested under a preliminary purchase and sale agreement near the Chernovy Kotur metro station. And this object is not listed in your electronic declaration for the year 2023. Why was this object not declared in your 2023 declaration?
Дякую за
2023 declaration.
Thank you for your question. At that time, when I was dismissed from the civil service, I considered that project as the ongoing construction project because it wasn't completed yet. This was a new building that the construction works only began in spring 2021, and it was being built rather actively before the invasion by Russia. And I would say that the carcass was already there. And at that time, I thought that this was the object of non-finished construction. And at the end of 2021, in December, the National Agency on Corruption Prevention has provided the comprehensive explanation. But because before that, there wasn't such comprehensive explanation. And given that the practice in Kyiv Minsk But was under a preliminary purchase and sale agreement, so I didn't specify it in 2023 declaration because in the agreement it was explained that these agreements are not the ownership of the object of the declaration, but of the constructor. So it was all done in accordance with explanations of the National Agency on Corruption Prevention. And after I got the explanations, I also contacted the authorized persons on corruption prevention in our body, and they advised me to store in my declaration for 2021 so that I didn't hide anything. And now we are providing the declarations in accordance with explanations of National Agency on Corruption Prevention. So there should be no questions on this matter. I act clearly in line with the instruction of the NACP.
Explain the amount of funds you invested in this property under construction, and of course the source of this fund.
Ну,
I have provided you the certificate for Kyiv Minsk But stating that 1,200,000 244 thousand is the amount in our declaration 2021, and we had some remains in the bank accounts that allowed us to pay this amount without problems. And apart from that, before that we exchanged currency in online banking, and we paid it in a non-cash, in the cashless form. And this was our salary and our savings, so we could afford it. The payments were done during the year. My wife has reflected all amounts that were over 51 living minimums in her declaration in 2021 in about the financial expenditures in accordance with the explanations of the NACP.
And my last question, before I pass the floor to my colleague. You stated in your written explanation that your daughter lived from 2015 to 2019 and your wife from 2015 and to 2020 in the apartment you purchased in the year 2009. Could you explain us why in your electronic declarations for the period 2015-2020 in the section 3, real estate, you did not indicate the right of your daughter and wife to use this apartment?
Дякую за
Thank you for your question. I am surprised where this necessity occurs. since the state bodies, the civil servants are obliged to act within the constitution and laws of Ukraine, the law on corruption prevention, Article 46, that defines the data that are to be reflected in the declaration in chapter the real estate, specifies that you have to specify that the real estate in accordance with the agreement of sale and purchase, lease, and other deeds based on which the subject of declaration on his members got these objects. But since I live together with my family and we didn't make any transactions, and the element of the rule of law that is the standard of Council of Europe and that is envisaged in Article 8 of the Constitution, there is the requirements in accordance with the report of the Venice Commission. So no such duty origins from the law. I gave the norm of the law, and considering that we did not make such transactions, that's why I didn't specify or indicate. Apart from that, in another chapter of declaration, I specified the residence of the members of the family of the subject of declaring, and I have specified their place of registration, since, as far as I understand, at that moment of time, the practice has been only generating, and many times the forms were changing, amending. And at that moment in time, there were no explanations of the NACP on account of the situation. And if such explanations, clear instructions were in place, I would act upon them. Apart from that, my wife has indicated the factual place of residence in her declaration that she has submitted. And logically, if all members are indicated in the declarations, so in accordance with Article 1 on corruption prevention, where their definition of these notions are, they were residing with me. And if they didn't, I would not submit that information. So there is no such duty. At least back then, but since it has occurred, now I am providing it in accordance with explanations that exist.
Your explanations, and I'm passing the floor to my colleague, Mr. Vasil Shakun, who will continue with posing questions to you.
Oleksandr Volodymyrovich, we have a few more follow-up questions regarding your income. Mainly, in your electronic declaration for 2023, you indicate approximately more than 1 million hryvnias and almost 115,000 in foreign currency as monetary assets placed both in bank accounts and available in cash. Could you dwell on this? Explain the sources and formation of these monetary assets. Thank you for the question. It cannot be that amount. I think it's a lot less in foreign currency in 2023. It's not possible. There was some miscalculation. I have a declaration, and I can, so in your name, 640,000 hryvnias. 11,999 USD and 1,500 euro in different bank accounts, and also 3.5 thousand euro in cash in the name of your wife. So 496,000 and $18,000 placed in different bank accounts, and also $27,000 in cash.
This amount objectively cannot exist. Maybe someone made a mistake during calculations. These are absolutely legal funds received from our salaries. These are remaining funds from the previous years, which were declared by my wife in 2020 to 2022. I do not submit declarations right now. My wife declared these funds in her declaration for 2022. That is within the framework of remaining funds from 2022 and within the framework of those salaries which we received in 2023. Foreign currency was bought for deposits based on possibilities provided by the National Bank according to its resolution, and all of these funds were absolutely legal. Okay, clear. On August 13 of 2020, your daughter and her husband each purchased one land plot in the village of Hotanivka in Vyshgorod district in Kiev region. Your daughter's land plot had the area of uh, uh, 0.0654 hectares, and the total area of your son-in-law's land plot was 0.072 hectares. What was the purpose of buying these land plots, and how are they used? Can we please close the broadcast, because this information is not about me, and this is information about my daughter and her husband, who live as a separate family, and I would not want to disclose public information about other people. Please suspend the broadcast. On June 13 of 2024, the Grand Chamber of the Supreme Court adopted a ruling under the case of Judge Usatый. In connection with this, civil society organizations expressed concerns regarding this ruling. In its report dated October 30, 2024, the European Commission also emphasized that this decision of the Grand Chamber of the Supreme Court could undermine the qualification assessment procedures involving the Public Integrity Council until December of 2023. As the advisory group has established, you provided your academic opinions regarding such legal provisions interpreted by the Grand Chamber in this case. How can you comment on that? Thank you for your question, Mr. Vasil. First of all, I would like to say that I do not know who provided faulty information to the European Commission about the change in the practice, because this practice did not exist back then. According to the current legislation, a judge, co-rapporteur of the Grand Chamber, and all the procedural codes stipulate this provision. And I also worked in the Supreme Court as the academic secretary of the Academic Council, and I know all of these procedures. The opinion is sent to the Grand Chamber in this particular case when there is no precedent regarding the application of this provision of law. I received a letter from the academic secretary Tkachuk in early May, so that I would prepare this opinion, and these issues that were subject matter for discussion at the meeting of the Consultative Council, and it was not specified under which case I had to provide the opinion. It was just about my opinion about interpretation of Clause 20 of Final and Transitional Provisions of the Law on the Judiciary and Status of Judges, dated 2016, where it was specified that it was clearly determined there that judges who, as of the moment of this law coming into effect in 2016, held positions of judges appointed indefinitely, or who were judges appointed by the president for 5-year term, were subject to undergo qualification assessment by the HQCJ, by the panel of the HQCJ, and pursuant to the conclusion of the panel of the HQCJ, if they were considered as non-compliant, then such person was to be dismissed by the HCJ. So this clause clearly stipulated that that it should be done upon recommendation of the panel of the HQCJ. Why was this provision adopted? In total, in Ukraine, we have about 8,000 judges. Back then, we had fewer judges when the law was adopted, and it was done so that the HQCJ could deal with this qualification assessment. And by the way, it did not manage to complete it. I mean, the first composition of the HQCJ appointed in 2016. And it was stated that these issues were to be evaluated by panels of the HQCJ. And there was a meeting of the Consultative Council, and similar positions were voiced by leading law schools, for example, the Kiev Shevchenko University, Yaroslav Mudry National Academy. They provided completely identical conclusions. Besides, I studied the absence of such practice. I was conducting a search in the register regarding this clause. Besides, during the meeting of the Consultative Council, there was voiced information that materials regarding the draft law adopted in June of 2016 were reviewed, and this provision emerged during the second reading. So materials regarding the draft law were studied, and it was a will of the legislator. It was clearly determined. Besides, the fact that this particular position was voiced, the legislator also expressed this position, because the legislator amended this provision by adopting the law, stating that the HQCJ was supposed to take a final decision regarding this. This logic in actions of the legislator showed that this was the approach. Moreover, this opinion is not the source of law, is not an undeniable ground for the adoption of the decision by the Grand Chamber. Judges are independent. They use their own understanding of provisions of the law. The opinion of the member of the Consultative Council is not even evidence in the understanding of the law. Judges take a decision based on their own legal consciousness and convictions. Besides, no problem emerged in this respect. Thank you for your answer. Now we are coming into the lecture. Let me ask you a follow-up question. Can you please tell me, you answered and you presented your opinion as a member of the Academic Consultative Council or as a private individual? Since I'm a member of the Consultative Council at the Supreme Court, this information is available at the website. Okay, it's clear to me. Thank you. Thank you for your answers. Oksana. Dear colleagues, yes, please, Yaroslav. Thank you, Madam Chair. Oleksandr. My question will be about Pleskach's statement that the AGE received, and it concerns this case of Usatый. Citizen Pleskach is drawing attention to the fact that in the past you worked as academic consultant of the judicial panel on administrative cases in the Supreme Court. A judge of that panel back then was Judge Kriventa. Judge Krivenda, while being the judge of the Grand Chamber of the new Supreme Court, was a rapporteur under Usate's case. In connection with this, Citizen Plaskach makes an assumption that you prepared your opinion not accidentally, because this particular opinion became the basis of the decision of the Grand Chamber. So, Citizen Plaskach assumes that Judge Krivenda could order from you this particular opinion. You prepared this opinion upon his request, that you preliminarily agreed the text of your opinion with Judge Krivenda. Can you please explain this situation, maybe refute these assumptions of Plaskach or confirm them? Thank you, Yaroslav. First of all, that is not Citizen Plaskach, that is disciplinary inspector at the HCJ, who is, yes, since recently. Probably along with consideration of complaints against judges, he sends letters to the AGE as a citizen while performing his main work. You, as a former president of the Supreme Court, could see that we did not have any close relations with Oleg Viktorovich, even though we worked in the chamber, and I also prepared academic opinions. And while yes, I remember you had purely professional relations. Yes. I don't even have his phone number. I have no means of communication with him. I work in this academic consultative council purely upon instruction of the academic secretary of the council at the Supreme Court, Oleg Tkachuk. No relations with him. So, you received materials from the Academic Consultative Council at the Supreme Council? Yes. To the member of the council, right? And you did not get in touch with Judge Krivenda regarding this. Do we understand you correctly? So, assumptions of Citizen Plaskach are not accurate. Back when I worked in the Constitutional Court, he always had some problems with transparency, some assumptions, some conspiracy theories that the CCU is hiding some information from him. He submitted numerous claims against the CCU that some information was not provided to him. In my opinion, he has to deal with his work and not to deal in conspirology. Thank you. Dear colleagues, are there any other questions to the candidate? If there are no questions, Mr. Oleksandr, now you have up to 5 minutes to address us with concluding remarks. Thank you. Thank you, Ms. Oksana. I would like to express my gratitude to the honorable members of the AGE. I have my goal to which I'm striving, and Madam Maureen O'Connor is the US judge, and Yaroslav was the president of the Supreme Court. And Vasil Shakun was also a member of the Consultative Council at the Supreme Court. The very honorable composition. It's a pleasure for me to be able to take part in this competition. First of all, I understand that Ukraine is fighting at two front lines right now. First of all, that is the front line of resisting the Russian aggressor. We should express our gratitude to the armed forces, to the air forces of Ukraine, which allow us to take part in this interview. Besides, we have another front line, that is Ukraine moving in the direction of European integration. In June of 2022, on the 22nd of June, there was taken a decision that Ukraine became a member for accession to the EU. So accordingly, having relevant knowledge, experience in this sphere, I have decided that maybe my knowledge and experience could be of use for the state. Since in the Ukraine facility plan, it is envisioned that one of the steps towards a fulfillment of Ukraine's commitment under Chapter 22 is conduct of successful procedures for filling in vacant positions of judges of the Constitutional Court. At the end of this month, there will emerge a crisis because the Constitutional Court will lose its quorum. They will have 11 judges. 3 judges are retiring because of age, and maybe my knowledge since I used to work with cases under proceedings and I know the methodology of drafting decisions. I think that maybe my knowledge will be of use. All financial questions I would like to say that I have official income since 1999. Since 1998 I have started teaching in Yaroslav Mudry University since the second year of my postgraduate studies. I was involved as into teaching since then, and since then all of my income has been reflected in tax declarations. And thank you for this opportunity to take part in the competition. Thank you, Mr. Oleksandr, for your answers. Dear colleagues, dear public, I am hereby declaring interview with a candidate for the position of the judge of the Constitutional Court of Ukraine, Konstantyi Oleksandr Volodymyrovich, completed. Thank you.